Now, in this video, we're going to be talking about a very recent development that's taken place at the Supreme Court involving the denial of certiorari for a couple of cases and the relisting of another couple of cases, all related to the Second Amendment, of course. Many of my colleagues that are involved in the Second Amendment bar that are doing YouTube videos and Instagram videos and things like that have been over the last 24 hours trying to explain to the public what's actually taking place as it relates to these cases. This video is going to be a little bit different. In this video, I want to talk about the Supreme Court itself, because by looking at some of the comments on some of these other videos, I'm realizing that a lot of people just really don't understand how the court works, and more specifically, what ultimately could transpire as these cases move through. So first off, let's talk about the way a case makes its way to the Supreme Court. As you guys are all well aware, you have a trial court. That trial court renders a decision. That decision then goes up to an appellate court. An appellate court either upholds that decision or reverses that decision. That is then ultimately sent by the losing party, of course, to the Supreme Court of the United States. Now, there's a couple other pathways that a case could take, but this is the general one. Each case that goes before the Supreme Court does not get an automatic hearing at the Supreme Court. There's thousands of cases that the litigants petition the Supreme Court for review. The way that it works is that a lawyer will draft what's called a petition for writ of certiorari. This then goes into conference. All 9 justices get together and they look at these cases, and then they will vote as to whether or not they want to hear a case. Now, it takes 4 justices to agree to hear a case. Keep in mind, it takes 5 justices to win a case. So there are times where you might have a justice that is absolutely interested in, giving us some good, judicial decision on the Second Amendment, but they realize that they don't have 5 justices on board that would then win the case. The 4 will hear it, but they're going to end up losing the case. This is how things were when Scalia was on the bench. So a justice that is pro-gun, I'll use that obviously in a generic term, might actually vote to deny cert because they don't want the case going to the Supreme Court and then getting saddled, losing the case at the Supreme Court, and then getting saddled with bad law for a generation. There's this sort of, little, star chamber where they look and they say, okay, we're going to hear a case or we're going to not hear a case. If they decide not to hear a case, then the motion for certiorari is denied, and the lower court ruling, the most recent lower court ruling, is what controls. And this usually the case, it's going to be the appellate court. On the other hand, they could say, we are going to grant certiorari, and then the case moves forward to a formal hearing that takes place after the first Monday in October during the court's next session. In this particular instance, we had a conference. We had, that star chamber where all of the justices got together. There were 4 cases that we've been tracking. 2 of the cases are what we call hardware-based cases. These are Snope v. Brown and Ocean Tactical. These deal with so-called assault weapons and standard capacity magazines. There were a secondary 2 cases that were in conference. These cases were Gray v. Jennings, as well as Maryland shall issue. The Jennings case and the Maryland case were denied certiorari. All right, we're done. Those cases are over with. The other 2 cases, the hardware-based cases, have been reconferenced. They said, okay, we're not going to make a decision on this now. That's an option that they have. We're not going to make a decision on this now. We're going to relist this for conference at the end of the week. And then we might get a decision on Monday of next week, or it may get pushed back again. Sometimes these things happen on a fairly, consistent basis. They get pushed and they get pushed and they get pushed. Now, the two cases that were denied, one of them was kind of a wonky case that dealt with injunctive relief. Now, I say wonky, it was actually important. I would have liked to have seen this case actually go to trial. This deals with whether or not at the time that a plaintiff asks for an injunction, if their Second Amendment rights are being affected by the imposition of a law, and they're saying, do not enforce this law while this case is going through trial, is a denial of Second Amendment rights a per se irreparable harm? That term that I just used, per se irreparable harm, that is a legal term of art. It's one of the requirements for a lower court judge to issue an injunction is that they have to find that the plaintiffs are going to suffer an irreparable harm. Now, generally speaking, when a civil right is being implicated as a result of a law, that is a per se irreparable harm. Not all courts have taken the Second Amendment as being, muscular enough, to borrow the language of both Justice Scalia and Justice Thomas, not being muscular enough for the court to find an irreparable harm. This was essentially requiring that the Supreme Court articulate that a denial of Second Amendment rights is a per se irreparable harm. Would have liked to have seen it, but it is what it is. We didn't get it. The other one in Maryland shall issue, this one involved sort of like a pre-licensing requirement. I won't go into all the details on it, but it was essentially a question as to whether or not the state could enact certain barriers that would make it more difficult for people to be able to exercise their right to bear arms. Okay, not necessarily to keep them, but to bear them. In any event, the court decided that they didn't want to hear those two cases. The other two cases, though, are considerably more interesting. These could have larger scale implications. They could also set a certain groundwork that would be incorporated into these cases that were delisted, that were denied. So ultimately, at the end of the day, we don't have a definitive answer. There isn't, I've seen a lot of commentators, non-legal commentators, essentially pontificating that this ends the Supreme Court's interest in, moving forward in Second Amendment analysis. I don't think that's true in the least. They look very carefully at the cases that they want to tackle. Oftentimes, and this is one of them, oftentimes, there is an underlying statute that is being challenged. And the statutes, you might have one case over here and one case over here, both looking at competing statutes from different jurisdictions. And on first blush, they may look the same, but one statute is more onerous than the other. And they decide, we're not going to listen to this one over here. We're going to listen to the more egregious one over here, because effectively the ruling that we give is going to affect the one over here also. Okay, guys, I'm pausing this video for just a moment. USCCA, which sponsors these videos, they're doing a giveaway. It's very cool, but you're gonna want to get on it relatively soon. Now, you can read all about it in the description below this video, but it's something you're gonna want to do. All right, with that, let's get back to the video. There's a fairly complex level of analysis that goes through this whole thing. In any event, that's what's taking place right now. We do not have a loss at the Supreme Court. We also don't have a win at the Supreme Court. We have basically neutrality at the Supreme Court. But hopefully within the next few days or a couple of weeks, we should get more clarity. In any event, if you would like to email me directly, by all means do so. You can email me at stephen@artemishq.com. You can also go to my YouTube channel, which is at the Artemis Defense Institute, and you can see my Coffee with Stephen blogs that I put out every week as well. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.